Tell me, man. Pardon? 22. Hearing matter. IA. 22.
Along with IA.
Along with IA. No? You go for the appellant. Respondent. For the NCB. I see. Yes. LDB. Yes. LDB. Respondent prosecution. Where is allowed? List the matter on this Monday. Okay. 23-3. Okay.
Wait, Lordship. With the consent of the other side, I beg to mention item number 12, Lordships.
12.
12, Lordships. Am I weighing on behalf of respondent number 2, Lordships?
You want it another day?
Yes, sir. After the Bihu vacation, Lordships. After the Bihu vacation.
Oh, sorry.
Idiot, Lordship.
P. Dot. For the phone number 2, submits that same.
As the
And praise for listing the matter. The Bihu holidays first. Where is allowed? The interim bill stands extended till the next date of listing. List, I fix a date or just leave it to the registry? List only 22-4.
Yes, Lordship. Already.
When? Tomorrow? Yeah, please.
17 and 18, Lordship. Medical emergency, Lordship, the conducting councils.
No problem. Will. Yes, 17 and 18. No?
17 and
17 and 18. 6 adjournment due to some medical. Case diary received shall be interim. The order is there. Interim order is there. Not sure. Have to check the file. No? Huh?
Time is not there.
Not there. Anyway, we'll. When should I fix it? When should I fix it? When should I fix it? 37. Or check the number again. But it was 17, 18.
Mhm.
Yes.
The Lordship, as a listing of IA, Lordship.
When? Move to take as well. Okay.
Please, your Lordship. 38 application. Lordship will find the FIR. It starts from
483.
page
Application.
9, my 11 portion. Your Lordship will find at page 12. May I read my list?
FIR is at page?
It starts from
Page 9.
page 9. 11 portion. Your Lordship will find at page 12, my lord.
Relevant portion at page 12.
May I read my lord?
Right.
With due respect, I have the honor to report that on 2/11/25 at around 10:30 p.m., information was received by a reliable secret source by the OC, the PS, that a gang of dacoits was loitering in the Khanapara area under the jurisdiction of for the purpose of dealing fake Indian currency notes and preparing to commit dacoity. Accordingly, the matter was informed to the senior authority. As directed, I, along with SI so and other staff of Bokhisto Police area, to locate and detain the said gang of dacoits who were reportedly loitering FICN and planning to commit dacoity. Upon reaching the spot, a search operation was conducted at strategic points in Khana. During the operation, 2 suspicious vehicles were noted waiting by the roadside. The vehicles were intercepted and detained. One swift vehicle bearing registration number so and so, registration number so and so. Both vehicles were thoroughly searched in the presence of. During the search, a quantity of fake Indian currency note, bamboo stick, and other incriminating material were recovered from their possession. Accordingly, the following persons were apprehended and taken into custody. Kindly note the persons who were apprehended, my lord: Muhammad Ali, Zakir Hussain, Suruz Ali, Ainul Haq, Alaluddin, Amir Hussain, and Abul Kasem. I am Sahil Sikdar, my lord.
You are?
Sahil Sikdar, my lord.
Okay.
I am not arrested from the place of occurrence. Later on, police arrested me, but nothing has been recovered from my possession. Sir, already I think the investigation might have been completed, and today is 71 days I am behind the bar, my lord. And my lord, one thing kindly consider, my wife is at an advanced stage of pregnancy, my lord. There is none to look after her. Considering the length of detention and the medical ground, my lord, I may be allowed to go on bail, my lord, at any condition, my lord. Furthermore, tomorrow, day after tomorrow is going to.
Have you annexed any medical document?
Yes, I have annexed the medical document. Worship will find it as from page 25 onwards, my lord.
This two are motions. Case diary is available in this case. Because I think
Available,
the
my lord.
supplementary is the bail hearing.
One is bail hearing, man.
Bail hearing. So diary is available. That
There
means.
is available, man. Just
Diary is available.
I'm going through.
Okay, take the time, no problem. I'm just trying to, I'll flag mark this thing. This is the one, 30 GMC antenatal OPD.
There are two persons.
This is Sahil
There is
Sikdar.
another Sahil, my lord.
Sahil Sikdar. There is another Sahil.
Yes, my lord.
ES 15 is Sahil. Sahil.
One or two item, my lord.
Okay. Okay. Other two are new matters, right?
Yes,
New matters.
But it is related, my lord.
Date of arrest is same.
Yes, Amit Lordship. Lordship, the FIR which has been read out, Lordship,
Uh-huh.
by learned friend, Lordship.
Mhm.
Lordship, the FIR was lost prior to the arrest of this petitioner, Lordship. And upon this FIR, Lordship, the other accused were been arrested. But it will be clear once Lordship will go through the forwarding, Lordship, which is at from page 21, Lordship.
Mhm.
On page 22, the brief is there. The gist of the case is there, which has been read out by the learned friend from item number 1, Lordship. And after that, in the last part, Lordship, the last part, it will be clear. Accordingly-
Your party is Islam Ali.
Yes, accordingly,
Sahil
all
Sikdar.
the
Both
three
were
persons
Anas
were
Ali.
apprehended.
The
They-
three petitioners in these three bail petitions, they were forwarded by this,
Yes.
all the three.
Yes.
Anas Ali is one of them, Sikdar, and this person, right? Okay, Islam Ali. Okay, fine.
As per FIR, the earlier recovery was made from those persons.
Those
Lordship.
persons.
Now, from my petitioner, Lordship, the sum of amount of 2,27,000 of allegedly FICNs were recovered, Lordship,
During investigation.
during investigation, Lordship.
Mhm.
Lordship has found the relevant para, Lordship. On
the forward-
page number 22, Lordship.
22, yes, I found. Sikdar. Kill that, so and so.
Last para, Lordship.
King counting mission. Oh,
Upon some statements or we have been apprehended.
perhaps.
That is their, Lordship. That is the facts, Lordship. Lordship, now the present petitioners, all the petitioners are behind the bar for last 72 days, Lordship. It is a 90 days offense, Lordship. Lordship,
They were arrested on the same day, of course.
same date, Lordship. Same.
Connected matter may take enough time, my lord.
I'll give you time, don't worry.
My lord,
I'm
that is
just
going for the
preliminary
last
submissions.
issue.
Okay. So this is the thing, basically. Right? No problem. Take your time. Go through it thoroughly. Slightly challenging case. Then we'll take it up.
But I'm sorry, Lordship, and I am for the 31, Lordship.
You are for 31.
31, Lordship.
Mm.
But
He's,
apparently, Lordship, the
he's
forwarding-
this Anas Ali.
Unnecessary.
Same forwarding, right? 72
But
days.
My little submission, Lordship, apparently from this forwarding report and the detail list, Lordship, nothing has been from my possession, Lordship. And subsequently, I have been arrested, Lordship, and whether
So
to
in that forwarding, there's a mention about some recovery, not
from
from,
me, nothing.
from one of the other persons.
Other person, co-accused, Lordship. And the forwarding report, page number 16,
We'll
Lordship,
see
is
all
very
this.
much clear. And even then, Lordship, the 21 is the seizure list, Lordship. There is nothing required from my possession.
I'll see. Okay. Give him some time.
Sir,
You study it, then
In the length of detention, maybe consider 71 days.
I'll
Plus,
see.
Lordship. Problem.
Okay, next.
Actually, your lordship. Lordship, in this case, the charge-sheeted case, lordship, and the POCSO, lordship.
Notice.
Yes,
Charge-sheeted. Mr. M.A. Mondal and Goswami. And additional people. Also. Call for the scan PCR comprising case diary, charge sheet and other relevant documents. The depositions have not started. Of POCSO has not been registered. Fakiragram PS case number 60 of 2025. From the court of the, it will be from the
Till-
Special Judge Kokrajhar. Kokrajhar. Full stop. The petitioner is in custody since 26/12/2025. Steps of notice shall be taken upon the informant impleaded as respond number 2. Notice shall be submitted before the office of the or notice shall be submitted before the office of the learned public prosecutor and to be executed by the list the matter on suggested date. Suggested date.
Lordship, it's from TCR, my lord, is Rajaras. 8, my lord.
Yeah.
That is right, my lord. After Bihu, my lord. 24th, my lord.
24.
plus
Yes, my lords, for 83 applications.
Just a minute. 24th April, you said. Won't it be late?
Because,
He has gone or not 24? Okay. Oh, okay. Already gone. No? 20 late, little bit lead to confusion otherwise. 24/4.
because the
20
certificate case.
24/4. Okay, sir.
Yes, my
please.
lords, 483, lords, the FIR, my lords, be pleased to peruse the page number 13.
This is also POCSO.
Costco, my lords.
Take the procedure. Call for the scan copy and notice. Anything else you want to say?
And the
You
one
can submit if you want to say something.
FIR page number, FIR page number 13. It is respectfully submits that I am the permanent resident of village, the Barkasarang, that's the name of my daughter, is the Swapna Fangsu, is about 16 years. She on 15/10/2025 left for the her school situated at Samata Pathar, but when she not returns to home by evening, we much worried. I suspect that Mohammed Saddam Hussein of Tulsi Nagar has developed with her by this system. One at there is the name of the two accused person has been mentioned at the bottom of this Q1. This is the Saddam Hussein instance. It is in fact, Your Honors, that they are friends, Your Honors, having some the love relationship also. On that day, that is Your Honor, the 15/10/2025, they went to Pabitra, Your Honor, for moving, Your Honor. And it was some late, Your Honor, on their returning and on Your Honor, the friends, Your Honor, that's of the victim, alleged victim. He refused to take the Your Honor, the girls, Your Honor, as such, Your Honor, the parents of the accused, Your Honor, they produced the victim girls and the boys, Your Honor, of Sonapur police station. So on the 15/10/2025, Your Honor, and on 16th, he was the Your Honor. The forwarding report is the Lord, page number 20. On 16th, he was arrested, Your Honor. Lords,
1610.
16th, 10th, he was arrested, and on 17th, he was the medically examined. That's the victim.
So I think
Medical, Your Honor.
to follow this one.
There is in medical, there is no any, Your Honor, there no any violations from mark is detected, that there no any signs of, Your Honor, sexual relationships, Your
It's charge sheeted also.
Charges are framed, my lord.
Honor. Your Honor.
Charges are framed. Anyway,
Also,
but Mr. Yo,
Why sit there?
why Sigda?
Why sit there?
Learned counsel, B goes. Learned. Call for the scan TCR comprising charge sheet. Charge sheet, case diary. And other relevant documents from the special sessions case number 226 of 25. From the court of the learned Special Judge Pokso, Kamrup M. In bracket, corresponding to Sonapur PS case number 175 of 2025. Steps of notice be taken upon refer, same, informant, immediate as respond number 2 through the, that's why I said that. This is the matter on
my lord, can be,
7-4. 7-4.
448,
You want it on 4?
748, oblige, my lord.
7-4.
I don't know, 5.
This is a second bail application, Lordship. We were arrested on 19/20/07/2025, Lordship. And
I mean, time charge sheeted, right? Second bail application.
Lordship,
Let us,
Lordship 240.
let us see.
Earlier rejection order, page 40.
Yes, I've seen.
Paragraph 7, lordship.
I've seen.
Charge sheet file on 13/10/2025.
Let us get a up-to-date, kind of status report. Third, Ayu Chaudhary, Learned Counsel. It is fairly submitted that an earlier bail petition was rejected on 8/1/2026 in BA 4029 of 2025. The case is, has already been charge sheeted and pending at the stage of trial. The prosecution submit that charges have been framed already. At that time, when we took up the last time, charge was not framed probably.
Charge was not framed as per the order.
Has it been framed? So instead of scan copy, should we get a status report and the depositions?
That will do.
That will do.
But that, my lord,
Because the scan copy would be available here.
here.
The scan TCR, which was called for in connection with the earlier bail application. I can you just give the number.
A number 4029.
Maybe put up by the registry. Order, call for a brief status report from the learned trial court regarding the the present status of trial of GR number, do you know the sessions case number? No. GR number 1023 of 25, within bracket Ramakrishna Nagar, PS case number 56 of 25. From the, we'll call it from CJM, Sribhumi,
CGM,
the court of the, might have been,
committed lordship.
no, the charges if framed, then from the court of the, from the learned trial court, it remain like this.
Charge probably not yet framed.
The learned trial court. The district of Sribhumi. Along with the status report, copies of charge order and depositions, if any. Scan copies of charge order and depositions, if any, may also be sent. This is the matter on 8-4.
Deeply obliged.
Lordships. Here, my lord, the petitioner number 1, the student of BA first semester, my lord, and 2 is the brother, 3 is his sister, and 4 is his mother, my lord. The incident took place in a mobile repairing, my lord, shop, my lord. Actually, my lord,
They're all this Papi Ahmed is his sister, and Rabia Ahmed is
Rabia mother, my
mother.
mother.
And what about petition number 2?
2 is the brother, my lord, elder brother. All the petitioner number
What
1.
happened?
FIR is at page 12, my lord. Actually, my lord, that phone, he damaged the phone, the informant damaged the phone after.
Let us read it.
it.
Oh, one statement. Let us read it.
I'm reading, madam. I, Raja Iftikhar Soikia, son of Bakhtar Hussain, am the proprietor of Mega Electronics located at Baramboy, Hazu. I am writing to lodge a formal complaint. It is his, my lord, writing complaint against the following individuals residing at North so-and-so place for theft, creating public nuisance, trespassing into my shop, and threatening my life. Thereafter, my lord, these names, details of incident. Theft. Yesterday on 11 February 2026, Haibul Ahmed stole a mobile phone from my shop, Mega Electronics. When I identified the theft and stated I would file a case, he returned the phone. Trespass and harassment. Later that same evening, Haibul Ahmed returned to my shop with his elder sister. They forcibly entered the premises and refused to leave when asked, and created chaotic situation, disturbing my business operation. Threat to life. On the night of 11 February, the elder brother Hazibul Ahmed called me my mobile number so and so. He used abusive language and explicitly threatened to physical harm me. Repeated trespass and assault. Day on 12 February 2026, Haibul Ahmed returned again, this time with his mother and elder sister. They created a scene inside my shop, refused to leave despite repeated requests, and attempted to physical harm my friends who were present at the shop. Then evidence, I have preserved the CCTV footage of theft, the trespassing, and aggressive behavior of the accused parties inside my shop. I am prepared to hand over this evidence to the investigation officer immediately. I am now fearful for my personal safety and security of my business, my lord. That is the allegation. Actually, what happened, my lord, petitioner number 1, he gave a mobile phone for repair. But the informant could not repair the mobile phone, he damaged the phone. Subsequently, my lord, some altercation took place. He gave a, my lord, mobile phone. After coming to home, my lord, he, my lord, published some video of taking that phone and altercations in the social media, WhatsApp.
The problem in social.
Subsequently, my lord,
Everything to social media.
another FIR has been lodged by her mother, my lord. That it pays, my lord.
Page 20.
20, my lord, not 20, my lord. Mother laws and FIR, that is at 26, my lord.
Anyway, I think let them record their statements.
Fine.
No issue. You don't have to live telecast your life. Isn't it? IBC is so important. Heard, still. Working 482 BNSS, the 4 petitioners herein who are stated to be anticipatory bill in connection with Hajo PS case number 68. Full stop. Petitioner number 2, 3, and 4 are stated to be their brother and mother respectively of petition. Case arose out of an dated 12/2/2020 caused by one Raja Iftikhar Saikia. The gist of the allegation was that on 11 February, the petitioner number 1 stole a mobile phone from his shop named Mega Electronics, but subsequently returned the phone. Later, it is further alleged that on subsequent occasions, he, along with his elder brother and mother, came to the shop and created unruly and aggressive situation. The learned counsel submits that actually number 1 had given a mobile phone for repair, but it got damaged in the shop, whereafter there was an altercation. But that the version of the FIR is exaggerated. All for the case diary. Or in the interim, in the event of their arrest, connection with this case, be allowed to go on bail of rupees 20,000. Okay, 20,000 with 1 surety of the like each to the satisfaction of the arresting authority and subject to the cooperate with investigation before the IO for examination. Number 3, not in any manner intimidate, harass, or harm the informant. List the matter on
Highly available.
Since there is the evidence of CCTV.
the objecting to bail submits that there is electronic evidence pertaining to the allegations.
Highly available.
List on, take the date.
Date, date.
Take the date.
Hello.
After viewers.
25th.
25
Alright.
4.
I've already. Oh.
Oh, yes, yes.
Yeah,
27 4. Okay,
Lovely.
27 4.
Please, your lordship. Otherwise, my lord, POCSO section 12 is there, my lord. If your lordship will kindly see the FIR. FIR is at page number 22, my lord. Basically, my lord, there was a scuffle between the, my lord, child of the informant and the child of the accused, my lord. And that, my lord, dispute escalated, my lord, between the families, my lord. And thereafter, my lord, this FIR came to be lodged. This FIR, my lord, was registered under 351(3) and 12 of POCSO Act, my lord. Oh, my lord, we'll only see one thing at page number 25, my lord. Last page. The petitioner, my lord, was on interim bail, my lord, throughout the investigation, my lord. 25, interim bail order is hereby cancelled, my lord. Last page, my lord, page number 25. And, my lord, only after recording the statement of the victim, my lord, his interim bail was cancelled, my lord, without recording any findings, my lord, whether, my lord, he had threatened the prosecution witnesses or he had, my lord, tampered with the evidence. Nothing, my lord, no findings recorded, my lord, straight away.
Very
his
small
interim bail was
victim.
cancelled.
Actually, no, victim statement is incriminated.
Yes,
Uh,
my lord, that
it's
will
a
always be there.
Very small girl. Anyway, actually, I left the question open actually that Nayak,
Yes, yes.
so whether interim bail can be granted. You know, the term bail has been used, which per se includes the term interim bail also. So I was suggesting that clarification can be taken from the. Sometimes there may be a situation where interim bail may be justified, because it may be necessary to protect. You cannot say that there will be never a situation where, but By the time notice is given, this may not serve the purpose. So since it's a division bench order, therefore I'm slightly handicapped. So it's better to take a clarification because question will come in many many cases, many cases. But for the moment, I left at that. I and I did not take a contrary opinion.
That judgment, my lord, the purpose was that, my lord, at least the victim should get a notification that a bail application was filed.
Notification. Even if interim is given, she can always come, oppose and get it modified. Because there may be situations where protection may be necessary. And judgment, so we cannot. Personally, I am of that opinion. So I did not express it, but I indicated it in my order. Left it at that. Anyway, so let us quickly have the procedure. You take the steps to the police. Okay. Call for the case diary of, this is the investigation stage. Call for the case diary of Polagons PS case number 26 or 26. But as thus, steps of notice, same. Inform to the concerned police station. Date
7, my lord.
process
So,
takes time.
yeah,
That is
some-
the thing, no? That
and
is the
also-
point. This has its own, this takes its own time. Yes. You
And also,
better, I think, to verify that. Anyway, 7-4.
Hello.
Okay.
Highly okay.
Yes.
In anticipated
Nawab.
bail application, lordship will find the FIR at page 8. May I read the FIR, my lord? Please accept my greetings. Last night at around 9:45 p.m., it came to light that the below named accused made different allegations against me during Facebook Live. He was seen using very harsh words against me. During this Facebook Live, he stated that in 2001, during the last term of the government of the then Chief Minister Prafulla Kumar Mohanto, two youths from Sodharu village of Biswanath, Raju Munda and Pushpak Wala were killed. Now, in the eve of the ensuing elections, that person has alleged that those murders were orchestrated by me. He further stated that the intention behind the murders was to ensure the defeat of the candidate from the nearby constituency, so in the 2001 elections and also my own ministerial ambitions. He did not stop there and he was seen making many harsh and critical comments. By way of this Facebook Live post, the youth has made concocted allegations against me the eve of the ensuing elections and thereby sought to harm me socially as well as politically. He is seen to have attempted seeds of discord in our otherwise peaceful society. He also caused the security. Bare reading of the FIR,
What offense?
at best defamation, my lord. At best,
Defamation is not a police case.
cannot be a police case, my lord. Now they have registered this case under all kinds of sections, my lord, criminal intimidation, then 296, that is earlier 294. Defamation, they have still registered it under defamation, but it can't be a defamation FIR. Then there is 352, intentional insult to invoke breach of peace. Then public mischief leading to commission of offences against public tranquility or commission of offences against any particular class or community.
The main grievance is that, of course, election is coming and he's a city government. So he's saying that he is responsible for someone's death earlier.
Even if it is assumed that I have made this statement, my lord, this is at best a defamatory statement. For that, the option would be to file a defamation, either suit or a complaint. FIR for none of these offences is made.
These are the sections pertaining to, you can just
My lord, I'll
give me the gist.
Section 351, your lordship, is criminal intimidation. That is earlier 506, which is bailable. Then 296 was the erstwhile 294, my lord. Obscene acts in a public domain. That is again bailable, not 356 is defamation. Bailable, but again cannot be an FIR, my lord.
That's settled.
Then 352 is intentional insult to invoke breach of peace. That is again bailable, my lord. Only non-bailable sections is 353, my lord. 1B and 1C. So 1B is regarding public mischief inducing to cause commission of offense against state or against public tranquility. That is again not attracted. Then 1C is public mischief with intent to incite commission of offences against any class or community. So it has to be against Prima facie, my lord, even if it is accepted as true, and I have made these statements, the election time, my lord, some political rhetoric will always be there, my lord. Even if it is distasteful, option is to file it.
People are also becoming very irresponsible about social media.
Right.
As I said, someone had told me
Don't
this.
have the right to, my lord, intrude upon the personal
No,
life of-
Manes, many people, once someone elder to me had told me, believe me, that, Ranju, when you grow up, you'll realize how important is, when you become older, he said, older than now, then you will realize how important is this privacy thing in life. It is not necessary for a person to live telecast, as we
I
call
figure, because
their life. No, necessary.
Files,
Not necessary.
because of
If
Facebook Live now, lot of people have themselves projected themselves to be journalists.
all are journalists.
Everybody is a journalist now.
That's fun also, but the thing is that it has an implication.
But my lord, during
You say good things in
Yes.
media, something you know, something these things can create complications.
but he has some restrictions invoked.
No, liberty is very important. Speech is very, very important. The thing is that our
Reasonable
threshold
restriction.
for tolerance also has to go up in the
Yes.
days of, electronic media. That is also true. But the thing is that people should also be, realize that self-discipline regarding social media.
some restraint is very necessary.
Already it is affecting our kids so much, because health-wise. Anyway, that is beside the point.
Yes, we
Heard
could have
S.
to file a
Nawaz.
complaint, my lord.
He'll record his statements. No problem. S. Nawaz Land Council MP Gosam. Invoking 482 BNSS, the petitioner is seeking anticipatory bail in connection with PRPS case number 28 of 26. Full stop. The allegation was lodged by Padma Hazarika, the member of Legislative Assembly of Assam from Nadwar LAC, in the of Sonitpur. The grievance of the informant is that the petitioner made some baseless allegations against him during Facebook Live, casting aspersions about his involvement in the death of some persons in many years back. Full stop. It is stated that during election time, such act of the petitioner has apart from harming him, has also can also create social problems. Full stop. Mr. Nawaz Learned Counsel submits that at best, while not admitting, the ingredients could constitute defamation for which police investigation cannot be done legally as per the settled law. That the informant will have to take recourse to a suit or a complaint. So it is submitted that the only bailable section, non-bailable sections are section 353(1)(b) and 353(1)(c), pertaining to creating mischief,
Public mischief, my lord.
creating public mischief by way of
By way of statements causing public mischief, 1B would be, my lord, intending to
statements causing public mischief with
Intending
intent to
com-
cause
commission of offense against
commission of offense against state
or
or
against-
social harmony
or against public tranquility.
or against public tranquility.
And then
Full
the
stop.
second part is to incite commission of offense against any class or community.
It is submitted that the ingredients of the non-bailable provisions also would not come.
Without an offense, my lord. Offense on the Facebook.
This is in the call for the case diary from the concerned police station. However, to enable the petitioner to record his statement, it is directed that the interim, in the event of his arrest in connection, so and so, 30,000 with one security, subject to the condition that number one, shall cooperate with investigation, shall not, he shall appear before the IO for record. He shall maintain proper decorum, especially in social media, in his words and deeds. That's all. What else can I say? This is the matter on
Report, my
24/4.
appear, my lord, within
I've given, I don't give a time frame usually. Do you appear?
I'm deeply obliged.
Number 9.
Please, the Lordship. Person here is bail, my lord. The Lordship will find the FIR, my lord, at page 10, my lord, the typed copy, my lord. May I read out?
It's 10.
Page 10, my lord. With due veneration and humble submission, I beg to inform you that yesterday on so-and-so, the officer in charge, Agomoni PS, proceeds to conduct mobile patrolling duty in the area by Agomoni PS GDE number so-and-so. Later on at about 4:50 am, the officer in charge, Agomoni PS, informed me over phone that he had intercepted one 16-wheeler truck, registration number so-and-so, with coal and one Hyundai Eon 4-wheeler bearing registration number so-and-so at Bhamdagra, near 1.5 kilometer of Assam-Bengal border, and the said coal was transported to West Bengal through secret village routes. Under the officer in charge, Agomoni PS, immediately I rushed to the spot, rushed to the place of occurrence and found that the officer in charge, Agomoni PS, apprehended the below noted 5% along with the above mentioned vehicle, and after enquiry it is found that they were carrying the said coal to West Bengal through secret routes of Agomoni in fear of paying tax to the GST department at Sagolia OP, and the person coming in the Hyundai Eon car was helping in the said offense. Thereafter, I have seized the said 16-wheeler truck registration number so-and-so loaded with coal and one Hyundai Eon 4-wheeler vehicle at so-and-so in presence of witness, and the seized articles and apprehended person were brought to the PS for taking further necessary legal action. My lord, this line, my lord, now, my lord. Then the driver of the said truck produced one GST invoice which was stored in his mobile phone, but it was found highly suspected to be forged, my lord. So I am the owner of that truck, my lord. Now your lordship may kindly turn to page, my lord, 20 for a once, my lord. 20, my lord. This is the e-way bill, my lord. Below your lordship will see, my lord, serial number 5, my lord, vehicle details, my lord. My lord, the same vehicle, my lord. My lord, the GST e-way bill was there, my lord. But the police, my lord, said,
Yeah,
my
the
lord,
police said that it's forged.
suspected to be forged.
Suspected to be forged.
To be forged. I am the owner, my lord, of the truck and the coal, my lord.
He was also in the truck
No, my lord.
at that time. He was not.
And my lord, those 5% who were, my lord, apprehended, they were released.
They were
They were released by the police.
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 Yes. What do you say? I have to see the case diary, of course.
My lord.
You must be seeking interim also.
Yes, well, I'm seeking interim. Hari money.
Dr. Learned Counsel and MP goes invoking 482 BNS. Is seeking anticipatory bail in connection with Agomoni PS case 12 of 2026 under so and so sections. The application in the FIR dated 19/2/2026 logged by police official that information was received regarding carrying of illegal carrying of coal from Assam to West Bengal. Accordingly, search operation, a patrolling operation was carried out. The police party apprehended a truck bearing registration number WB 64F2798. Sorry, a 16-wheeler truck bearing registration number AS19AC5127, loaded with coal, and also apprehended, detained one Hyundai Eon vehicle bearing registration number WB 64F2798. It is alleged in the FIR that the person in the Hyundai vehicle was helping the truck in the transportation of the coal. The persons in the vehicles were apprehended and the driver showed one GST invoice which was suspected to be forged. It is alleged that during inquiry, it was found that illegal coal transportation has been going on from some to West Bengal. Thing is that it is submitted by Mr. Datta that the 5 persons who were arrested by the police were subsequently released. They were never arrested, perhaps then they are allowed to go. Full stop. And can you just repeat your submission? He's drawn my attention to a copy of the
It's 20.
GST invoice,
E-way
e-way bill,
bill.
e-way bill, and also an invoice.
Yes.
Tax invoice. Full stop. And submits that these are genuine documents. The petitioner is stated to be the owner of the vehicle. Call for the case there. However, petitioner can be given an opportunity to record his version and his statement. In such view, 30,000 with 1 0, same conditions. Investigation, not hamper or temper evidence, and shall not commit any illegal activities or offences. This is the matter of
28 April.
I'm obliged, my lord, deeply obliged.
this one.
Earlier,
Oh, okay,
because
sure,
it is
sure. Sure, no problem.
in ML.
Yeah, no problem. Learned
Representative, my lord.
earlier, huh? The earlier one. Learned additional PP. Objects to the grant of bail, states, including the grant of any interim protection.
And
May please. And the petition, my lord, FIR is at page number 12, my lord. May I read, my lord? Page number from 13, my lord. This is the operative portion. This is a translated copy, my lord.
Yes. Ultra bus. Projected conduct is not good. That is
What happened, my lord? Purchased the bus and I already paid ₹6, my lord, and I installment. But what happened? There are some problem in the bus, therefore I could not pay 2 installment. But I have apprised the owner, my lord, and I requested him that I will pay. But he come to them to my place and told me that you should give me the bus. Then I said that I will give the bus, but you should return back the money which I have paid for purchase. I have give you the for purchase. Already, my lord, bus has been seized from me, and I have an information that Jima has already been given up to the owner, my lord. I only need ask him to give me some times,
the owner. He happens to be the owner.
my lord.
On record.
I have annexed the agreement and the money receipt which I have paid, my lord, that also been I have annexed, my lord. Agreement is at page number 21, my lord.
What is the name of the informant?
Name of the informant is, my lord, Abhigyan Dwara.
Dwara.
Page number 22, Abhigyan Dwara, my lord.
This is Priyanka Saikya,
Priyanka Sakia is the wife, my lord.
wife of
Wife of
Abhigyan.
Abhigyan Dwara. I paid the money in the account of Priyanka Dwara. My lord, CD may be called for an interim protection, maybe all the bus has been given.
Mr. M. Hussain, learned counsel. M.A.I. Hussain, learned counsel for the petitioner and K. Boyso, Mr. Invoking 482, the petitioner is seeking anticipatory bail in connection with Golaghat PS case number 28 of 2020. An FIR dated 3/2/26 was lodged by Abhigyan Dwara against against two accused persons with the allegation. White sale deed dated 5/8/25. He sold his ultra bus bearing number AS04BC 2425 to the accused number 2, who agreed to pay the installments of the bus. But the accused number 1 / the petitioner, by violating the agreement, sold the bus to accused number 2. No, he sold it to accused number 2, right?
My partner, I did not sold him, he's my partner, my lord.
But he said it in a,
That is the allegation, my lord.
by violating the agreement, sold the bus to 2 without informing him, and that the accused, they have also defaulted in paying the installments, and they have also not paid the tax on the vehicle. Full stop. It is further alleged that the GPS of the vehicle has been deactivated, and when he went and asked for the vehicle, they abused and threatened him. Full stop. It is submitted by the learned counsel that they had entered into an agreement whereupon they had entered into a commercial agreement, and that the petitioner has also made payments towards the installments, and in support of the same, drawn my attention to the documents annexed indicating payment by UPI to Priyanka Saikya, who stated to be the wife of the informant. It is further submitted that in the meantime, the Jimma of the vehicle have already been given to the informant. Call for the case there, however, in the interim, warrant of arrest in connection with this case, 25,000 with Pansevut. Cooperate. I'll endeavor to settle the civil side of the dispute with the informant.
No.
The matter on 28/4.
28/4.
28/4.
Yeah, please, your lordship. This is a case, section 16, that is the criminal piece of trust, and 318 of BNO, that is sitting, my lord.
Look,
Canon 318 subsection 2 is a bailable offense, my lord. This section 316 subsection 2 is a criminal piece of punishment is 5 years, my lord.
criminal breach of trust.
Piece of trust. But bare reading of the FIR, my lord, lordship may kindly see the FIR, my lord, in page 11, my lord. It does not disclose of any criminal breach of trust, my lord. Reference to the subject letter, I have to that the informant is himself with the OC Laluk PS, my lord. An information received from a reliable source that 2 passengers carrying illegal fake gold and were reportedly traveling from Bangalore towards Laluk via the state highway in a 4-wheeler vehicle, Hyundai Creta, so and so. Accordingly, vehicle was intercepted at Laluk bus stand near NS15 at around 3 p.m. and detained 2 persons on verification that disclosed their identity so and so, so and so. Both the accused persons arrested on the spot. And one of the co-accused at deal afternoon, Jia Roman, who was the driver who drove the vehicle at 11 point of time, and 20 numbers of fake gold as alleged by the police recovered from the vehicle.
May have more than breach of trust, it may have elements of cheating.
My lord,
I think it will be better to call for the case diary only in this case.
I think has been only the co-accused has been arrested and
What is the name of the petitioner? Khairul Alam.
My name is, I have been implicated in this case on the basis of the statement of co-accused, my lord. It is a previous bill, my lord.
He is not Dil Afnarul Alam. And
No, my lord, no. They were enlarged on bail by the my lord and trial court, my lord. Lordship may kindly see the page 13 and 15, my lord. They payload the line, pass by the line, court bill, my lord. And no any agreed person, my lord, caused any FIR to the police station. They have been seated, they have been by the any accused by.
the petitioner is not named.
Not named, my lord. I have been only edit on the basis of a statement of co-accused, my lord, who were arrested by the police and they were also enlarged on bail by the on subsequent by the trial court, my lord.
It's the Gogoi,
Yes, my lord.
as Gogoi, Learned Counsel. The Bush, so. But this network thing might be there, actually, it may be there. Anyway. 482, invoking 482, Laluk PS 23 of 6. Case aroused out of an FIR dated 1/2/26, caused by Simonto Pathak, Laluk PS. It is stated that reliable information was received about two persons carrying illegal fake gold in a Hyundai Creta vehicle. And accordingly, the vehicle along with the two persons, namely Dil Aftanur Alam and Jeunur Rahman, Zeanur Rahman, were detained, and seeing their suspicious behavior, a search was conducted, which revealed 21 numbers of both separate suspected fake gold weighing 35.962 kgs. It is also alleged that apart from trying to cheat innocent people, the recovery could also be indicative of a larger network operating. Learned Counsel submits that the present petitioner, Khairul Alam, is not named in the FIR, and his name has been revealed only from the police is looking for him on the basis of statement of co-accused who were arrested. They have been released on bail in the meantime.
Yes, my lord.
It is submitted that the arrested accused persons named above have also been released on bail in the meantime. Call for the case diary, however, to give a chance to the petitioner to record his statement and his version is directed that in the interim 30,000 with 1 cigarette. Cooperate, appear. He shall not misuse his liberty to commit any illegal activities or offenses, or any activities of the nature alleged in the FIR. List on. Give a date, person. Wednesday, holiday, Sunday. Twenty-three. 4.
I plead your lordship. Lordship, in this case, lordship, allegation is 366 IPC and 4 POCSO, lordship. And after the filing of the charge sheet, lordship, total witnesses, 8 witnesses, lordship, and all witnesses examined.
All witnesses.
All witnesses examined, lordship. And lordship, what happened, lordship? And since 13/12, this case is fixed for argument, lordship. And since 13/12/2024, lordship, the PO is on leave till today, lordship.
Okay.
Yes, lordship. And all witnesses examined, lordship. And page 66.
Saigon, Kokrajhar.
Kokrajhar.
Kokrajhar. So till today means joining tomorrow.
Yes, lordship.
Joining tomorrow.
No, no,
The
lordship.
judge will join tomorrow.
Since 13/12/2024 till now.
You don't know
Court
till.
court is not available. PO is on leave, lordship. And page 66, lordship, I annexed all orders, lordship. Yes, examined, lordship. And since very long time, the accused petitioner is the bar, lordship. And 610 days. I annexed all orders.
Did we complete the, you are appearing for the informant? He's agreed by this. And the scan copy has been received.
Scan copy received, my lord. Other record.
There's a previous bail application, but it is not by me, Justice
the second bail.
Cut off, sir.
Yes, Lordship.
I can take up.
And kindly, Lordship, hamper temper is not, Lordship, in this case, Lordship, already examined all witnesses. Kindly consider 610 days, Lordship. And since very long time, Lordship, PAC on leave. Now the case is argument stage, Lordship. Any terms and
I don't
conditions,
know
Lordship.
what is the nature of the deposition, but anyway,
On the
so
next date, Lordship, argument, hearing and Lordship judgment will appear, Lordship.
what did
Any
you like to
condition,
say?
Lordship.
I just,
The status argument state, your next date is fixed on 27/3 of 2026.
the learned judge is on leave. No, any idea when he or she is joining?
Check, your lordship, the learned judge is out of station, your lordship. Your lordship.
Any
Uh,
condition, Lordship.
I have not seen the depositions, otherwise the evidence is almost complete. But again, if there is
Yes, Lordship.
conviction, again, he'll have to go back because depends what is the nature of the prosecution case. I don't know. We should not express any opinion of
Yes.
course. Some implication is there. Are you opposing the bail or no? You are opposing the bail?
Available on the record.
There, some, but we cannot express any opinion at this stage. Any, what do you say, question?
What my learned friend's submission is that, my lord, as per the record, my lord, that is my 313 examination complete on my lord, 8/10/2024.
Argument stays.
Yes, my lord. And my lord, it is fixed for argument that is going on only
Very late.
that from a long time, my lord. That is my
He has
lord,
been in-
the PO is in leave, my lord. And as per the record available with us, my lord, that is my lord, 2010/2025 was fixed for argument. Now my learned friend from the my lord
2210.
10/2025 was fixed for my lord argument.
Okay.
And my lord, from the my lord, that is court, my lord, after searching of the e-court, he the next date for my lord, that is fixed on my lord 27/3/2026. On that, otherwise, my lord, it has already come. Kindly peruse, my lord, at this stage, not go for the comment on that part, but my lord, may kindly peruse the PW once, my
I've seen.
that part, my lord, and questions is very clear.
Yeah.
Yes, Lordship.
Anyway, so
Any terms and conditions, Lordship.
MU
Yes,
sorry, Mr. M.A. Mondal,
Mondal.
learned counsel for the petitioner. A. Boyso, additional PP, and A. R. Karim, learned counsel for the respond number 2. Invoking 483. Is regular bail in connection with Gosaigaon PS case number 76 of 2020, which after completion of investigation was registered as, what is a special POCSO case number 26 of 2021 and pending in the court of the learned special judge Kokrajhar. Is stated, it is submitted that the trial has already been almost been completed as all the depositions are over, including the examination of the victim, the accused under 313 PRPC, and the case is posted for arguments. The last date being fixed on 22/10/2025.
As per the, my lord, there is a record available not with us, my lord, as per the e-court, my lord.
It is
It is
submitted,
submitted by my learned friend, my lord, who is appearing for, my lord.
the Mandal Learned Council submits that the petitioner in custody for about 610 days ever since his arrest on 16/6/2024 itself. Full stop. Upon being noted.
Surrender.
Okay. On his arrest on the strength of NBW.
Thank you.
Just write like that. Since 16/7/2024. 10 copies available. Full stop. The prosecution and the learned counsel for the informant does not dispute that the prosecution evidence is complete and case is at the stage of argument. The Mandal Learned Counsel submits that argument has not been argument has not progressed. Argument stage of the case has not progressed as the learned special judge is on leave. Is on long leave at present. Upon considering the stage of the trial and the length of detention, I'm inclined to consider the prayer for bail. Accordingly, the accused is allowed to go on.
May I make a prayer, my last part of my lord. May my lord pray that my lord, one my lord government COT, my lord, his attendance will be there, my lord.
50,000 with government security. Can you manage government security?
Personal lordship.
So sometimes what happens is that considering the nature of the case, NDPS,
Yes, yes.
POCSO, sometimes government people may hesitate to be securities. That is also a
Only
problem.
Because
That is also a problem sometimes.
so, my lord.
But we have to ensure two
If, my lord,
securities.
he flew, my lord.
Two securities.
Yes, lordship. Yes.
Two securities.
One, my lord, the local, my lord, then.
50,000 with two securities of the like amount, one of which should be a security from the district of Kokrajhar,
From his, my lord, that is.
subdivision of Gosaigaon, from Gosaigaon subdivision. Practical, sometimes, you know, the government, I've come across, they hesitate. Some
But the
POCSO
same
cases,
like in
NDPS cases.
commercial quantity.
So, but if the relative or not, then he can. Otherwise, sometimes a poor person may find it difficult also sometimes. Anyway, so, but this is a legitimate concern, very legitimate concern that argument is over.
My lord, victim
He has
also
also seen what kind of evidence has been adduced. He's aware what kind of evidence is adduced. So he may get scared
my
and
lord.
50,000, we are taking a risk, you know. 50,000 with two securities of the like amount, one of which should be the one of local from Gosaigaon. So, and following conditions are important. Number one, the petitioner shall not abscond. The first the petitioner shall not intimidate or harass or harm the informant / victim side or any witnesses. That's all, or should I also direct his appearance then once something before the PS? Unnecessary. That is always there. We mention also. Securities. Let's see. Violation. No. He shall be available for the remaining trial. Violation of the bail conditions would entail bail petition stands allowed and disposed of.
Obliged, lordship.
My own life experience is that most people don't abscond. Most people don't abscond. My life experience. But some do. Some do. Now, because everyone has data, Aadhaar and everything, it is not so easy also. Because people can be tracked. But still risk is there because people can get scared. That is why the law is strict about granting bail in appeal, where sentence is very high. Life imprisonment. Because people, he may harm himself also. He may run away also. People, It's natural to be afraid.
My lord,
Obliged.
Item number 30.
Go on.
If there was call for, and the co-accused persons released on bail by your lordship on 13/3/2026, my lord.
A minute. Matter
He
30.
received, my lord.
It's 30. That kettles.
Kettle,
CD was here, no?
Yeah, my lord. The extorted, my lord.
Yes. Mhm.
Case of the driver is there. Identified this person.
But a group of people intercepts a particular vehicle in the night, and driver, my lord, directly identifies them, their names, my lord, mentioned. And my lord, the allegation of is of 25th February, and there's a delay of 7 days, my lord. That is also not explained in the FIR, my lord.
You have the order.
Yes, my lord, this is the earlier order.
Will parity apply or there are some special materials against them? They were arrested together, I think. Rightly or wrongly, one person has been granted bail. Hemango Pangi. একটু আপনি আগরটু পেলেন order. Okay, petition entry. The case diary as called for is received. The learned counsel sub order dated 13/3 passed in BA 640 of 2000 granting bail to co-accused named Hemango Pangi and draws attention to the narration in para 6 of the order. And may be reproduced here in below. Yes, yes, tell me.
At my lord, the similar,
That is true.
but the allegation is that has identified the driver.
Both the petitioners, as also the other co-accused who were granted bail, was arrested on the same day. That
Same.
is, they were arrested on
My lord, there was around, my lord, 3/3, my lord.
3/3/2026 and forwarded together. The learned additional PP submits that the investigation is not yet completed. Still going on. And order dated 17. Huh? Okay. Second last paragraph. Second last paragraph. Second last. It is in the given facts and circumstances, and also considering the aspect of parity, of the considered view that the petitioners should also be granted bail accordingly. Same paragraph, like say, allowed to go on. Is possible.
Highly obliged, my lord. May please, Your Honor.
I'm on interview.
We'll have to wait then.
Lordship, because it is
It is submitted by the prosecution that the case diary was sent for updation, but it has not been received back. Updated case diary shall be procured on the next day. Interim order passed earlier, passed on 4/4/2024-25, stands extended till the next date of listing. It's pending for a long time, so we should dispose it off. Pending for a long time, we
Can
should
you
dispose it
verify,
off.
Lordship, may kindly,
Nowadays, bail petitions are,
Yes,
they
Lordship,
should be, it's right also,
Lordship, may kindly fix on 4th, my lord. Till, my lord.
4/4, we should dispose it off because from 25 April it's pending. Should not be.
7, my lord, 4th, my lord, here. 10, my lord,
Okay.
7, 4.
But it's pending from April
It is-
2000, should
we have
not
to-
be, we should dispose it off.
Anyway, my
Whatever it is, there can be another bail application,
Lordship,
but one should not be pending. And there's now directive also, and very right also, that's very right.
Lordship,
On 7th, my lord.
And
16. Charge sheet has been filed in this case, my lord. He has got someone from the court also, my lord. PRC case 53 of 26, my lord.
So, Mr. Sharma,
Yes, my lord.
11/12/2020. 11/12. The petitioners were granted interim bail by order dated 11/12/2025. They have appeared,
No, my lord, 33 is the first date appearance.
no, sorry, they have appeared before IO,
Yes, that they have done, my lord.
submitted that pursuant to grant of interim bail, the petitioners have appeared before the IO. It is Mr. Sharma, the learned counsel also submits that as per definite instructions. Yes. In investigation is completed in the case resulting in a charge sheet, and that he has also received a summons by PRC number
PRC case 53 of 26.
26 full stop. Would you like to, that must be correct, but
yes, my lord. Yes, my lord, till is
no, you can take instructions regarding charge sheet. Then we can confirm, make it absolute. Telephonic instruction you take. Can you?
Instead of my lord. The summons were received, my lord. There is no. And they can pay for the regular bill. Till then, my lord.
I am showing my bona fide before this court, my lord, at least that appreciated. That may be made absolute, my lord. We
Matter
have,
of
we have
record, my
cooperated
lord.
also, my lord.
Matter of
Maybe
record.
made absolute, my lord.
Okay, then
Okay,
I will take the my lord instruction.
Kindly, my lord, because
You take the instruction, then we'll see. Then we'll decide. We can dispose it off with the direction to
My-
appear and something. You take the instruction.
Monday, my lord.
No, okay, will it be
2
possible
o'clock, my
tomorrow? Today?
Okay, I will
Today?
try.
You try it
can it be fixed at 2 o'clock?
after 2. Today we have reference also, but okay, 3:15. We have time.
Okay, someone to get.
Tomorrow we don't know. We may be more
Then
busy
it is a-
than
Someone
today.
is issued 30th, my lord. So it will not. Monday, my lord.
Telephonic instruction, if it pleases, my
Just try it.
Such-
Huh? If you have inconvenience, then we'll fix it on Monday.
2 o'clock. Deeply obliged.
Very busy.
Cannot get the phone, my lord.
Yeah,
I know,
yeah.
my lord, because-
Just try it
because
once. Just try it
always
once.
They are in the outer.
Not necessarily after 2. If he gets it now, before 1 also, it's okay.
I'll wait, my.
I get
I'm
it, my
obliged.
lord.
Yeah, yeah. Just try once. Otherwise, we'll fix it on Monday.
Such-
April.
Mhm.
Perhaps it is not there.
That's it, file, my lord.
Bring for some protection. Lord.
What is the allegation? Fake currency.
Fake currency. Lady lordship. Second bill application lordship.
Just laid down on 29/126, my lord.
What will be the sections?
The 170.
These are these are equivalent to 489 A, B, those sections.
Lordship, those sections, my lord, regarding.
But those will be triable by special judge now.
Yes, special.
Ramjit Singh after judgment, special court, NIA schedule offenses, right?
Approach there, my lord.
You like to approach the trial court?
Some protection will. My lord. Lady lordship.
There is no protection earlier, my lord. How can, my lord? Now the
Lady lordship.
Now the my lord. The seat already filed, my lord. And earlier it is rejected, my lord.
You good name?
SK Chetri.
SK?
SK Chetri.
Chetri. Learned counsel.
Page 16, lordship.
I've seen it. Page, no. Earlier bail petition was rejected on 9/12/2025.
It was also vacated, my lord.
On passed in AB 2692 of 2025. That's para 2 and 3 to Lolo.
Develop case the interim back.
Para 4 to Lolo. The prosecution submits that in the meantime, investigation is completed and it has resulted in a charge sheet. So, the learned counsel for the petitioner. Do you have the charge sheet number also? Right CS number?
CS number 3/26 dated 29/1.
In view of the completion of investigation, approach. Yeah, I will make some. I'll make some observations.
Order lordship.
Uh,
Yes. Lordship has ordered in protection. Some given some protection lordship.
Wait.
There was no interim order. Even then, lordship has some protection. I'm paying for some similar order lordship.
That's true. That's true. No, no.
Lordship perused the my lord, your lordship's order. Earlier interim was granted. It was rejected after perusal of the CD. The facts are completely different here, my lord.
In the given facts and circumstances, paid currency. Okay. Not counsel for the some things. Otherwise, these are serious offenses.
Yes, officer, but
Learned
there is
counsel
no-
for the petitioner
the state, my lord.
submits
Lordship. Being a lady lordship.
submits
Some protection will be given.
an order dated 19/2/2026 passed by this court in AB 3054 of 2025, granting bail in granting bail, and it is submitted that such bail was granted in similar circumstances with regard to similar offenses. There was the said order. Okay. This can be generalized actually, but still same conditions.
So I am praying then your lordship may kindly record, my lord. Page 20, if your lordship, page 16, my lord.
Mhm.
Page 16.
Yes, I've seen.
Yes, my lord.
Only because of completion of investigation.
Lordship has rejected the,
Yes.
vacated the interim order, my lord. Again, your lordship is.
Not can be subsequent ground is the completion
Yes,
of investigation.
completion of it. That is-
Completion of investigation. That is the reason.
Otherwise, my lord.
Otherwise, not. Learned additional PP submits that considering the nature of the alleged offences, bail, the bail should not be granted to the petition at this stage. Nevertheless, considering the completion of investigation and the fact that the petitioner happens to be a woman, I deem it, I deem it fit to grant bail the circumstances. Accordingly, it will be deposited.
Interim granted.
Was granted because it was projected that she did not know anything. She was a victim of circumstances, but I have observed that it may not be true.
Earlier order.
Yes, sir.
is-
Only because of completion of investigation. So, women to cut it off, not like completion of investigation. 7, 8, 9.
As per the earlier order, your lordship.
No, actually, if it is made absolute, you'll submit bail bonds only, The petitioner shall submit fresh bail bonds before the learned trial court, whereupon necessary orders may be passed. The learned trial court is also at liberty to impose further and additional bail conditions with regard to the petitioner as deemed necessary. Bail petition stands disposed. Trial has started, so. What is the one? Anybody for 13? Really going to have something. Pick it up. That's one more matter. Just wait for some time, madam.
13.
What is the matter?
After some time, my lord. After some.
The matter. Just let me see what is the matter. 13. Respondent name is also shown, counsel. Entered into an agreement in this case, but
In 20, my lord.
only POCSO, though it will be difficult.
Lordship.
No, revision, this item 13.
Item 13, yes.
They have entered into an agreement.
And
But
entered
if
the
it is only POCSO,
Also.
then it is difficult, isn't it? Only POCSO would be difficult in a sense. Let's see. Still, prima facie. After some time, this one. Yes, any other. I mean, 16 at us.
I'm sorry, my lord.
Yeah, no problem.
Your lordship will find the FIR, my lord.
You're for the informant? You're for the informant. Where is?
FIR at page 13.
Sin, yes. It is registered under POCSO only.
Yes, my lord.
But don't you think it will be difficult because only POCSO, only POCSO settlement,
Yes,
it
my lord.
not fall in the compound, the categories where, in terms of the law. Don't you think it will fall outside that? Anyway, let us see.
Now, my lord, she has now she is major, my lord. But there is a settlement, my lord, between the party that they are going to marry, my lord.
Scan copy is available.
Copy there, my lord. Search sheet laid down, my lord. And
Sheet has been filed. One, I wanted to see that statement. please.
183 also implicated, my lord.
You are not opposing, informant? You are not
Oh,
opposing?
জোর-জবরদস্তি করে
Yeah, I have read.
rape করে। Yes, yes.
How old, what is her age?
Yeah, इसकी बात है।
No, at the time of the incident.
He is recorded as 17, my lord.
And age of the accused?
22 years, my lord.
They had a love affair or something?
Yes, my lord. But actually, what happened, my lord? We also filed an FIR. That FIR is very important, my lord. At page 41 for a once, my lord. The cross FIR filed by the
know not whether IA is permissible under the present facts and circumstances of the case. Filed a revision petition against the
say revision against conviction,
Now,
concurrent finding, that is permissible.
my lord,
But charge, I was not sure.
My
I'm
lord.
not sure.
my lord. Now, my lord, so far as bail petition is concerned, IA is concerned.
It will be
has
infractious.
become infractious
You're
because,
sure that
Yes, my
this
lord.
will, so it's-
because the instruction that we have received, my lord,
that's okay.
but
Then.
this is the order passed by the learned trial judge, my lord.
We'll dispose it of them. But Mr. V.K. Sen, is it okay? Learned legal aid counsel for the applicant petitioner. K. Boysa learned additional PP. Full stop. Okay, this one. Review. Two and three to উঠাই দিব. Mr. Sen, learned legal aid counsel submits that in the meantime, the learned trial court has already granted bail to the petitioner. Support of the same, he has submitted relevant document from the CIS.
But the accused, my lord, could not furnish the bail bond, my lord, because the condition was
Regarding
such. That is why he has filed an application, my lord, for modification.
right order dated 10/3/2026. Before the learned
For
court.
the learned trial judge, yes.
No problem.
That is fixed for, my lord, hearing on 24th of March. That is the order, that order,
That's true.
it appears from the order.
In view of the aforesaid development, the present IA, which was filed seeking bail pending adjudication of this criminal revision, has become infractious.
My lord, revision petition will.
No, IA is
Yes, yes, my lord.
IA.
A revision petition will be.
Yeah,
will
that has to
fixed
be
for-
heard.
yes,
That has to be
that
heard.
will be-
IA seeking bail during the pendency of the revision petition has become infractious. Accordingly, the interlocutory application is disposed of as infractious.
My lord, the criminal revision petition may be fixed for admission hearing.
Let's see, what is the last
She is
order?
discharged, my lord. Then unnecessary, she is, my lord, dragged into the court. My lord, absolutely, my lord, your lordship will find.
You're here also, you're appearing as legal aid counsel.
My lord.
It has not come today for listing.
The lordship may fix it next
The-
week, my lord,
mm,
for admission hearing.
The criminal revision may be put up for admission hearing next week. Whether there's no date, 5/3 was the date. But I think, very nice, order nice one. Any, most probably. Been listed.
Lord may fix a date. my lord.
Today, only the IA has come, right?
Yes, yes,
Oh.
yes,
On, you want a date?
my lord.
27?
Deeply obliged, my lord.
Please, your lordship, can it be at two, my lord?
Can be. What is the, it's IA is for?
I for suspension of sentence and releasing the bail. Convicted for 4 years, my lord, under 8, my lord.
Sentence for 4 years. It's a very new, very new. Just been, he has just started undergoing the sentence, right? Inform it. Okay. You want to file a counter or something? So another date, let him file a reply.
Monday or Tuesday?
Let him file a reply. Your good name, please.
Khan.
You can learn it counsel for the appellant. Sorry, applicant. We'll stop. Additional PP and your. If Fogan is appearing for the amicus curiae, learned amicus appearing for the respond number 2, informant. The learned amicus submits that in this interlocutory application seeking suspension of sentence and bail upon conviction of the applicant under section 4 of the POCSO Act.
8.
Section 8 of the POCSO Act. Dash, he would like to file a written objection. It takes some time for the same. Prayer is allowed. This is the matter after week. After 10 days.
Date may be fixed, my lord. Right.
Hmm? Yeah, 30 will be best. 30. Hmm?
Replay. 1, 2, and 31.
Is your lordship.
Hmm.
Well, the
Let
gist
me
of
hear
the
him.
case was
Now let me hear him then. I've heard, they have addressed. You can reply. Now you can submit. Let him submit. Now then you can reply.
Matter, my lord, 3 numbers of accused person, my lord, in item number 1, Sahil Sikdar, my lord. Item number 2, my lord, Islam Ali alias Sahil. And my lord, in item number 31, my lord, Annas Ali. These are the 3, my lord, my lord. My lord, the accusation is very serious, my lord, the fake Indian currency note, my lord. Where, my lord, the first instance, my lord, a vehicle intercepted by the police, my lord, from where, my lord, that is the fake Indian currency note were recovered, my lord. Taking that lead, and during the course of investigations, my lord, these names came out, my lord. And my lord, thereafter, my lord, they are able to, my lord, name, my lord, that is, my lord, all these 3 persons, my lord. And my lord, that is Islam Ali alias Sahil. He has a, my lord, rented premise where these 3 persons were there. Taking the lead, my lord, these people are arrested. So it is a, my lord, very serious. And my lord, that is a, my lord, nexus, my lord. Yet, my lord, many things has to come out. So at this stage, my lord, if investigation, I kindly peruse the CD, my lord. I have flag marked the relevant position.
To make your reply, to keep it for chamber. Yes. Some submissions have already been made.
Sufficient time is
72
71
days.
days.
Hmm.
I am for Sahil Sikdar, my lord.
Hmm.
Sahil Sikdar actually directly involved in suspicious ground. He was arrested. Another Sahil Ali,
Hmm.
and he is a Sahil Sikdar, my lord. 71 days, sir. But there is some medical research. His wife is advantage is my lord.
Regarding wife. Sahil Sikdar.
Sahil Sikdar.
That is, it has been submitted, this one.
Yes.
Hmm.
Or my lord, 71 days is a sufficient period is behind the bar, my lord.
Okay.
Currency is recovered from his custody.
About it. Common,
Please, your lord.
common order would be there.
Elected submission, lordship. Petitioner, the Annas Ali lordship, his name is not appearing in the FIR lordship.
He was, they were, all 3 were arrested later.
Lordship. But otherwise, lordship, and mandatory period is complete. That because the section 179 will not come against the present petitioner. And the 180 lordship, and it is 7 years, and up to 60. 71 days in custody, Lordship. But they are not found in the position, Lordship, and they are delivering or using the fake currency as genuine. So 179 will not come, Lordship. Only 180 is possession, Lordship. But my possession is nothing recovered, Lordship. Mandatory is complete, Lordship. So, up to Honorable Court, Lordship. Obliged, Lordship. Item number 31.
No, sir,
Regarding
yes.
item number 2, Lordship, I have a submission to make, Lordship.
Yes, you submit what you,
Present petitioner
name?
Islam Ali alias Sahil, Lordship. Arrested and taken into custody for 2 days, Lordship. Because they are thoroughly interrogated, Lordship. Lordship, apart from that, Lordship, I have submitted some of my mother's medical document from page number 27, Lordship. And most recently, these documents are the mother of the present petitioner has been referred for higher treatment, Lordship, regarding seizure and liver disorder, Lordship. Also, I have annexed, Lordship. And during his custody, Lordship, after the police custody got over, Lordship, he has never been interrogated in the judicial custody, none any custodial interrogation has been sought. As today it is already 72 days, and my humble friend has made his submission, Lordship. As 179 will not come in this case, Lordship, as they have not tried to use, Lordship. Only the possession is there, and 180 will come, Lordship. And regarding that, 7 years will go, Lordship. A 60 days offense, Lordship, as days offense. And regarding my mother's illness, Lordship, he is the only son, Lordship. He needs to be present with his mother, Lordship, at this stage, Lordship. As already 72 days, and he is from Kamrup Metro itself, Lordship, not in the jurisdiction of the police, Lordship. If for completing the investigation, they needs any further interrogation, any stringent condition may be imposed, Lordship. That he will appear, Lordship.
Done. Oh, chamber. Chamber it. Okay. I'll consider.
Deeply.
I'll read it and consider.
Also, Lordship, I have submitted a bail order, Lordship, from the lower court, Lordship. That case was 68 days, the other co-accused were granted. We are on a better footing, Lordship, on already 72 days, Lordship. And regarding the medical, Lordship, deeply obliged.
Item 24.
All matter. Eleven maintenance matter. That's some kind of proxious. Then appears on call, full stop. Considering the fact that the revision year 2011 itself, the matter on Tuesday. Which day? So we had fixed, no? This.
Probably she will come. Otherwise, it's just 376. So 7 years, 8 months, 15 days out of total conviction of 10 years, Lordship.
That's why this is urgency.
Yes, Lordship.
We can do it.
Lordship.
You're ready, no? No, we can do it.
My lord, in the meantime,
Paper, do you have the paper book?
my lord.
Nice paper book is there.
It's already flag mark.
Not many witnesses also, 7. start, no? You can start and then at lunchtime you can inform her.
Oh, she will probably come. She was sitting there.
Single bench 20 matter, he has already solved. So FIR dated 6/7.
Lordship. Our lordship, this is by, at first their lordship, it was under 376 as well as POCSO, but subsequently it was found that she is a major, so its conviction is under 376 only. They frame under 376.
Not POCSO.
I have the honor to state that about 4 months ago, so-and-so, a resident of our line, called me to his house on the pretext
Nine and 10 means 6%.
Page 9 and 10, madam. Parikshit Rava and Manas Mess.
Yes, 5 and 6 in the
Yes,
charge sheet. Page 9 and 10.
page 9 and 10.
Okay. Yes, please.
Lordship, I didn't have not. I have your lordship's gun for my lord, that is.
Yes, yes.
My lord.
That's enough.
Yes,
But
my lord.
could you call? No. Would you?
So, because he informed me that he has got the cert. Then my lord, he is on. Can pray for the regular bail, my lord. I pray, my lord.
It may be made regular, my lord. I have already appeared before the IO, my lord. I'll appear on 33 also when the court, when
The alleged offences are a bit serious, however.
Yes, yes.
Anyway, PR Sharma, her paragraph 1. 11, 12 to 25 or the
46.
petitioners were granted interim bail on 11/12/2025. It is submitted by the learned counsel and that pursuant thereof, they have appeared before the IO and their statements have been recorded. Full stop. It is also submitted that in the meantime, case has been charge sheeted upon completion of investigation, whereupon both the petitioners have also been sent up for trial. The learned counsel for the petitioner has submitted a certified copy of the charge sheet submitted in this case. The prosecution does not dispute the contention about completion of investigation and filing of charge sheet. The present petitioners have been indicated as accused number 5 and 6 sent up for trial in the charge sheet. In view of the completion of investigation, the appearance of the petitioners pursuant to grant of interim bail and no material to indicate violation of any bail conditions. comma, despite the nature of the allegations, comma, I'm not inclined to cancel the interim bail. Full stop. Accordingly, the interim bail granted by order dated so and so is hereby made absolute, subject to the conditions that they shall be available for the trial if one commences. They shall not hamper or tamper with evidence. They shall not misuse their liberty to commit any offenses. They shall not intimidate, harass, or harm the informant side or any way, or try to influence any witnesses. Violation of the bail condition would make the bail liable. The bail petition stands disposed of. You can submit fresh bail bonds if you want. For
May I have
the
the copy of
petitioners
the-
are at liberty to submit fresh bail bonds before the learned trial court, whereupon necessary orders shall be passed. The learned trial court is also at liberty to impose any additional and further conditions, bail conditions, if so desired.
A submission that I have
The learned additional PP submits that they may be directed to appear before the learned trial court and seek regular bail.
My lord,
Yes, you wanted to say something?
my lord, may I have the copy, original copy?
Yes, yes, it's, that's yours.
My lord, my lord, he will appear only, again he will file one bail application, my lord, it will be contradicted.
No need, no
As
need
my
to file.
senior friend has just,
No need to file. No, that is a submission. Submission.
sorry, my lord.
That is a submission, no problem.
Sorry, man. I'm deeply obliged.
26.
Your Lordship, this petition has been prepared by this petitioner for quashing of the complaint proceedings, which is currently being pending as complaint case number 22 of 2019, the learned judicial magistrate Margarita. And the cognizance was taken in this matter under section 294, 325, 342, 352, and 506 of the IPC. And after the cognizance was taken, now this petitioner had preferred one revision petition before the additional district judge, which was not allowed by the honorable court, and as such, he had preferred this petition before this honorable. On the fact remains is that in this particular matter, the already this matter was stayed on earlier occasion.
He is basically aggrieved by the summoning order.
Not only the summoning order, but the cognizance which was taken on 7/11/2019, Annexure A, my lord, page number 23. This is the cognizance order.
Just a minute. Matters we have. They have not appeared. They have appeared, no?
The respondent number 2 and 3 have not yet appeared. We have
But service is complete.
yes, service is completed, and this particular matter is now been pending since 2025, my lord.
No, that's
Already
true.
steps have been completed.
Mhm. Because we don't want to come back again
Yeah.
for checking this
Yes,
case.
my lord.
But service report is not complete or what? That case, will it be advisable to take it up? Just a minute. Kindly see, check once. They were the complainants.
Yes, they were the complainant.
The complaint case,
Yes.
right?
Complaint case that
So-
that was registered against the
I see, I see.
this petitioner.
So
Now this
they-
petitioner, he is a policeman.
Okay,
He's currently serving as an SI in
okay.
Dhaka district.
That's okay. 2 and 3 are the way the complainants.
Yes, complaint.
Before the court. So their service is important, you know?
Yes.
Whether they come or not, that's
Yes.
their choice.
Yes.
But their service is important, okay? So
My lord, a report may be called for.
I
Whether
only office note, let me cross check, let me check with the office note again. You can also have a look if you want to have. The latest office note says that it is not yet received back. 17/3. 17 is yesterday, that's yesterday.
We have taken the steps.
Yes,
now.
it's not come back.
Yes, ma'am.
Can you take instructions? This is a complaint matter actually.
Now, what has happened is that, my lord, because of this pendency of the case,
Mm.
the prospects of this accused petitioner for his promotion
Yes,
is
yes.
now
I understand.
it is now in
That I understand.
dilemma, ma'am. Because the ACR will be prepared, and regarding this
You have
particular.
to follow. I go to the Rohit.
LCR was called for, my lord, on.
That is received, LCR?
LCR receipt. my lord.
You can draw the presumption
Fine.
of service, but strictly speaking, that's applicable to civil, but in criminal also, but it's a criminal case. But they are the complainant, that's the thing.
Under section 27 of the
General
general
clauses.
process, yes,
Mm.
can draw because we had taken the step in a proper manner.
What do you suggest? It's not come for a long time, actually.
Yes, ma'am.
Would you like to take fresh notice? I mean, as an option? Because that I understand, this matter should progress and should be
Yes.
decided because he's
Yes.
also stuck. He's also stuck.
A report may be called for from the jurisdictional police station or from the court, the jurisdictional court, since it will be done from that court. This will be whether it has been served or not, like what is the current update and status. Then we can draw from that particular report.
The petitioner herein is aggrieved by the order dated 7/11/2019 passed by learned JMFC Margarita, taking cognizance in CR case number 22 of 19 and issuing and summoning the petitioner. Full stop. The respond number 2 and 3 are stated to be the complainants, at whose behest the complaint proceeding was initiated. So the scanned, this will be sufficient. This will be scanned TCR is as called for, has been received. However, as per office note dated 26/5/2025, notices were issued to the respond number 2 and 3 by registered post with AD and through the DM District Magistrate Tinsukia on 18/11/2024. However, till date, neither AD card nor unserved notice or any service report received with regard to these private respondents. This is also reflected in the latest office note dated 17/3/2026. So what is the way forward? Will you take instructions? They have already overloaded. Take that will help him, Maybe in the end, he's also a policeman, so.
Yeah.
The prosecution shall take the respond number 1, which is the state of some represented by learned additional PPK Bush. Is so and so. The prosecution shall take steps, take instructions regarding the service upon respond number 2 entry. These days, police will be very busy
Yes.
in this days. When should we fix it?
Before vacation, my lord, if possible. 27 if possible.
It will be in which column? Orders column or hearing column only?
It will be in the hearing column only,
We fix it on 24.
my lord.
Sorry, no, not 24. Taking the wrong mark. 31st, Tuesday.
My lord.
You can come in the hearing.
Yes.
column. Then if necessary, you can upgrade it and we can take a call on this matter,
My lord.
on the service part.
Fine.
Even if we don't
Yes,
get
fine.
time to hear, we can
Fine.
take a call on this
My
matter.
lord.
31st, 31st.
And
7.
Praying for quashing of proceeding, section 138 NI. I have two contentions. First, my lord, that cause of action arose as the statutory notice has not been served. And the reason is that it was returned back for insufficient address, my lord. Secondly, my lord, the reason for which the check in question got dishonored, my lord, there is no, it has returned for no such account. So there is no,
There was no service according
no,
to.
no account.
No, first condition.
Yes,
condition,
there
no
is no
service.
service. It is admitted fact. It, the notice returned back due to insufficient addressment. My lord,
The second contention is,
second contention is that, my lord, the reason there is no such account.
there is no such account.
So there is no account maintained in any bank, my lord.
Okay.
My lord, for first contention, kindly come to page number 18, my lord. That is the evidence, pre-summoning evidence, my lord. Come to page number, my lord, 19, para 8, my lord.
Para 18.
Para
Sorry,
8, my
page 18.
Page 19, my lord. Yes, the relevant portion which I am relying. The evidence, my lord, produced by the complainant, my lord. Para 8, my lord.
Yes.
May I read, my lord? Proceed.
Yes, I am on.
Para 8, may I read, my lord? And that I beg to say that it is to be noted here that the said registered post with ID card is returned without service to me for the reason of insufficient address as revealed from the postal tracking file. So it is the admitted fact that no service has, service of notice has been served upon me, my lord. Now, section 27, my lord, of General Clauses Act, my lord, there is a presumption, my lord.
Yeah.
Yes, that presumption can be drawn, my lord, only when it is properly addressed, my lord. It is in the act itself, my lord, when it is properly addressed.
Registered post AD, proper
Yes, my
site.
lord.
AD nowadays not there, but
Yes, my lord.
registered post addressed to the proper address.
Yes, my lord. Now, for insufficient address, it has been returned back. Now, the burden lies upon the complainant, my lord, that the address in which the notice was issued, my lord, it was given by the accused person or from some document he has procured it, my lord. So in entire evidence, it is silent from where he has got. Now, accordingly, my lord, on this point only, my lord, the trial court has dismissed the case, my lord. That is at page number 30, my lord. Initially, it was dismissed.
By the trial court.
My lord, by the trial court.
Complaint was dismissed.
Yes, ma'am.
Page 30.
Page 30, my lord. That order, ma'am.
Just a minute.
As there is no cause of action arose, my lord, the case is dismissed, my lord. Thereafter, my lord.
Just a minute, let me see. All right.
My lord. Thereafter, my lord. The complainant has preferred a revision petition before the session judge, my lord, and a session judge. It was allowed, my lord. Case number 45, my lord.
And that is how you have come here.
Yes, my lord. Thereafter also, my lord, I have appeared before the trial court, my lord. I'm coming to that also, my lord. The reason cited, my lord, the reason for allowing the petition is that, my lord, page number 47, my lord, the operative part.
Okay.
My lord, operative part at 1-2, my lord. For page 47, my lord.
Yes.
My lord, 1-2, my lord, the
Yes.
operative part.
Hmm.
May I read, my lord?
Yes.
It is also seen that the accused and the revisionist complainant entered into a written partnership deed on so-and-so where the address of the accused is the same as given in the present case, and therefore the question of insufficient address does not arise as per section 27 of General Clauses Act and proviso B of section 138 NI Act. Once a notice is served in the correct address of the accused, the service is deemed to be effected. Again, as per Section 94 of NI Act, if the notice is duly directed and sent by post and miscarries, such miscarriage does not render the notice invalid. Here the citation so-and-so, Your Honor, was allowed, my lord. Now, this
Just a minute, the
agreement.
ownership deed. Hmm.
My lord, the agreement relying upon which, my lord, the revision was allowed is never a part of the evidence, my lord. They have directly brought it in the revision only, my lord. Not have been relied upon, my lord.
It was never a part of the trial records,
Yes,
according
my
to you.
Still not a part of the trial record, my lord. Now, my lord, as there was no stay, my lord, the trial court has proceeded and I have cross-examined the complainant, my lord, that I have brought on record, my lord, by way of additional affidavit, my lord. Page number 73, my lord, is the cross-examination.
Page number 73
73
of your petition.
of additional affidavit, my lord. Yes.
Affidavit, sir. Additional affidavit.
Affidavit, what they have, if they have filed anything.
You have not got copy?
Actually, your lordship, earlier amicus curiae was appointed for the respondent. We have
Okay, anyway, that has to be, then we'll have to just break. I'm not getting.
direction may be given, please.
It has come into the record, according to you. It should have come.
Long back I have filed, my lord.
It is there here. But you don't have a copy. Huh?
It has not been furnished to us. No? Earlier in this case, amicus was appointed, then we have appeared in after getting. That's why, my lord.
Just a minute.
Might have been missed, lordship, on that.
It is here.
A copy will be given, matter may be kept parted, lordship. I am ready to.
In that case, we have two options, either not to keep it parted and furnish the copy and resume hearing again. Otherwise, you proceed. And in the meantime, after any case today, we have time constraint till 3:15 only. because
matter
because of reference.
Yep.
So he proceeds a little bit, and then after today you furnished the copy to the Land Council, and we keep it part heard.
As your lordship deems fit, lordship.
What do you think will be
Yes, yes,
better?
lordship.
Okay, proceed that.
No,
You can proceed a little bit. We'll
Oh,
keep
okay,
it part
okay.
heard.
Because my
You
lord, my
argue for-
permission would be from this only additional, which he has not got, my lord.
Not that. No.
So that's why I suggest,
Part heard.
yes, my lord.
Lordship maybe kept it part heard, lordship.
Heard. Who appears for the revision petitioner. Addresses his arguments in part. However, the petitioner side has also filed an additional affidavit, which is available in the record. However, the escape order, learned counsel who is now representing the sole respondent, complainant, sole respondent / complainant, has not received a copy of the same. Accordingly, a copy of the additional affidavit may be furnished to the learned counsel for the if the matter as part heard, list on. So
May first week, lordship, if possible.
after May 1st week.
May 2 or May.
After Bihu would be better. Huh? Take a date after Bihu. Till 5th May. 5th May.
Obliged, lordship.
Obliged.
এখন থৈ দিব নে ভালকে বান্ধি ষ্টেপ
Eight.
Probably I'll not be able to complete it within 15 days, 15 minutes. Otherwise, there is no cases made out, my lord. What happened, my lord? We are in law. From the FIR, my lord, I take your lordship. Kindly peruse the FIR, kindly. They are in this, in law in college life, my lord. Page 28, kindly peruse it, my lord. Page 28. It is respectfully submitted that above named accused person is a dangerous cheater. That is me. I and accused person were studying in the GC college since 2006, and we are known to each other. By the way, we have